Welcome. I've written a book that many of you will find valuable. It's a global guide to competition law, also called Antitrust law. For most purposes, almost all purposes, competition law and antitrust law are the same thing. Competition laws can provide great benefits for all, but most of us know little, if anything, about it. And those who know something about it are often wrong. They sometimes know too little. They fill in the blanks in the wrong way. So I've written a short book that opens doors to the subject and how we can use it. I know of no other book like it, and I'm confident that it can be of much value to many of you. It's carefully constructed to be of value to those new to competition law, those who know a little and want to know more, and those who may know much about their own competition laws, but need to know more about other competition laws as well. They need to be able to understand what's going on outside of their own system, as well as what's going on inside it. Perspective is both domestic and global, because competition law today is both. It is both global and domestic. So why should you care? Competition laws can reduce the prices we pay, improve our choices as consumers, and create more and better jobs. They can also reduce income inequality, stabilize society, and support democracy. Each country is a little bit different in that regard, but each can get much value out of it. Competition law helps protect the capacity of competition to produce these benefits, so we can all gain from knowing more about what it is, how it works, and how we can use it for our own benefit. What is competition law? Basically, it's the legal principles and institutions that states use to combat restraints on the freedom of businesses to compete. Very simple, very straightforward. We don't want businesses to be restrained in their ability to compete, because if they are, somebody's got the power to do that and they're causing harm. The more robust competition is, the greater the benefits it can provide. Restraints on competition, such as agreements among businesses to raise prices, mergers to create giant firms that reduce the benefits of competition law and can harm all of us. All of those sorts of things are potential problems. We'll talk about that in a minute. Economic power fuels restraints. Economic power is what gives firms the ability to restrain competition, and it is a central concern of competition laws. Almost all states have competition laws, and many are active and powerful. So what are competition laws' goals? States use competition laws to pursue a variety of goals. Some people think there's only one goal. It's just some kind of technological or technical domain where there's only one goal, economic benefit. But there are lots of them in different countries. Some goals are purely economic, i.e. greater intensity of competition that allows markets to work more efficiently and more effectively. Very valuable goal, and some countries focus almost exclusively on it. The United States, for example, focuses very much, almost exclusively, on this kind of intensity of competition, these economic goals. But some goals in some countries are social or political. For example, the fairness of markets. In many countries, what they're really trying to achieve is fairer markets. The protection of minority businesses. In South Africa, for example, this is one function of competition law. Or the distribution of wealth. There's much evidence that competition law can help reduce the income inequalities and wealth inequalities that are so problematic, especially these days. Another set of goals focuses on economic development. Very common in countries such as many African countries focus on that type of goal. The book examines these goals and identifies the factors that lead states to pursue them. So it's important to know, why do states do certain things, and I try in this book to make that clear. It also cautions against relying on the officially stated goals. A country can say it wants to do certain things with its competition law, but it has particular goals. But sometimes what the states say are not really what they do. Sometimes they actually use competition laws to benefit themselves, benefit those in political power, or individuals who have influence on government officials. When that happens, competition laws can cause harm. But if we understand competition laws better, we can take steps to reduce those harms. Who applies and enforces competition law? Well, the book then looks at the institutions of competition law. Each system has at least a competition law agency, an administrative agency that is primarily responsible for applying and enforcing competition laws. In some systems, courts also play important roles, but the guide shows how different the institutions are and how different the roles that competition courts, and courts in general, play in competition law. It identifies the factors that shape how these institutions actually operate. It's not just about what they say or what the formal issues are, but the guide focuses very much on why they do things, what sorts of effects are involved. You might ask, well, what methods do they use? Good question. The guide then looks at the methods that the institutions use. Some are highly sophisticated economic methods. In some countries, such as the United States, in Europe, you have competition law economists, often very well paid, many competition law economists who do this in very refined ways, dealing with these are PhD economists. They're very expensive and they're very valuable in many ways. But most countries don't have such systems. They can't afford to have these kinds of focuses. And so they use broader, less technical methods that rely on judicial and administrative judgment and analysis. If you focus on economic analysis, it's of course important to have competition economists telling you what works and what doesn't work and what's right and what's wrong. But if you focus on things like fairness, well, then the judges and the administrators, they have to use their experience, they have to use their knowledge of the society, they have to use their understanding of how competition law consequences will arise. And we learn in the guide why this is so important to look at these kinds of issues. We haven't talked yet about targets. What do we mean? What are competition laws aiming at? There are basically three. All states basically have the same targets. Some do not have mergers, but we'll talk about that in a second. First, they identify and combat agreements among producers that are designed to take resources from consumers and give them to producers. Designed, in other words, to take money from our pockets and put it in the pockets of the producers. If producers are powerful enough, they can raise prices to us. And who benefits? They just take those higher prices and put them in their pockets if they can. If competition works properly, that doesn't happen. A second category of targets, so the first target is agreements among producers that can harm. Second one is mergers. Competition officials, competition authorities identify mergers and mergers among businesses that create firms that are large enough and powerful enough to reduce the benefits of competition. If you allow a merger between two large firms and allow them to have tremendous power within a market or in a particular situation, they are going to be tempted to use that power, and often do. So we try to have competition law officials and competition law agencies and courts stop mergers that have that sort of effect. And third, they identify and combat abuses of power by businesses that are powerful enough to harm competition by themselves. So if I'm a large company, think about Google, think about Amazon, I may have enough power to do all kinds of things that are not benefiting anybody except me, and might be harming my competitors, might be harming consumers. So if it's an abuse of power by itself, if it's used to foster competition, that's fine. But abuses of power to harm your competitors, to harm individuals, to harm consumers, that we want to stop. So those three categories are what are the targets of competition. As I mentioned above, there are more than 100 competition law systems in the world. I think I mentioned it anyway. And they influence each other in ways that we need to understand. So 20 years ago, it was not true. Right? 20 years ago, certainly 30 years ago, there were only a few competition laws. There was very little opportunity for them to affect each other, to influence each other. The EU and the US were the models, but there was no internet connectivity that made the constant, repeated, frequent interplay of information and influence what it is today. It's a tremendously important part of what goes on in most systems, and we'll talk about, the book goes into which ones are important, how they're important, what kind of a system we have. The US and the EU are the two most important competition law systems in the world. Those two competition laws, ways of doing competition, ways of doing competition law, they are the ones that other countries have used as models. The American model is certainly attractive to a lot of people, a lot of countries. The US model is shaped in a particular way that tends to favor certain kinds of benefits, right, economic benefits and so on. The EU model is a little more varied. It gets used by many developing countries, by many other countries. It is very attractive in countries such as Japan. It's been very attractive in countries such as Korea, in other countries that are looking for a little more flexibility, a little less emphasis maybe on the economics of the competition law system. These enable us to better understand any competition law, these factors that I'm talking about. So we have the EU chapter, the US chapter, and then another chapter that talks about how the different competition laws are affected by particular characteristics, so we understand why a particular kind of country, a developing country, a rich country, a country with a lot of openness to to trade and other influences. If we can look at all those things, even things like religion can play a role in some countries. Knowing these kinds of factors, which is basically, I think, the longest chapter in the book, enables us to understand any competition law. They focus the light on the competition law things to pay attention to in any system we encounter. So why a global guide? Maybe that's already clear from what I've said, but it's important to say that this guide is different than all the other guides that I know of in many ways, but certainly with regard to the fact that it's global, fundamentally global. It looks at different systems, of course, individual systems, but it looks at them as not for some sort of formal reason, but they're all understood as responses to common problems. Market economies have, by their nature, certain kinds of effects. And this approach allows us to compare competition law, recognize the ways in which foreign competition laws differ from our own or are similar to our own. This can be highly valuable in understanding or making decisions about any competition law. If you have another competition law that's doing something, you need to know why it's doing it, what kinds of factors can play a role. Equally as important, all competition laws can and do interact with and influence other competition laws. Their relationships are extremely important, so the guide shows how they relate to each other. It employs, I think, a very useful perspective. Doing that, one that I don't think has been used, as far as I know hasn't been used, but can be highly revealing about how the way the whole globe works in a sense. So I just want to comment briefly. The book can be of much value to many. Those new to competition law can use it as an introduction. Students, for example, people who don't know anything about competition law, they can use it's straightforward enough, very carefully crafted to be straightforward enough, so that people can get a lot from just trying to look through this book and pick up what the basic issues are. Lawyers, judges, and officials can use it to understand foreign competition laws that may be relevant to what they do. Business leaders can gain much value from seeing competition law problems they might encounter. By looking through the guide, you can get a sense of, well, what's different? Why is there a risk if we do something in that country as opposed to in that country? What kinds of problems can we expect from a competition law there and how it operates? And if we don't know that, it's very difficult to make good business decisions. And even lawyers who are very, very good in their own competition law systems. They are specialists, perhaps, even in competition law, but only in their own systems. Most, in my experience, I would almost be tempted to say all, look over to a different legal system, different competition law system, and don't really quite get it, don't really quite understand, and sometimes make huge errors as a result. So even lawyers who know a lot about competition law can learn a lot about other systems in this book and how they relate to what the lawyers themselves do. Just want to say thank you for watching. I'm confident that you'll find the book valuable.